so let me let them in.
You let Ms. Cargill in too, and I'll explain to them.
Okay, so let me let them in.
Okay. Good afternoon, Council. Before we begin, I just want to let you know that there's the Athelia Cargill. She's a court reporter and just sitting in this afternoon.
I swapped out the T-shirt in the garage, Your Honor.
Okay. Ms. Thomas, we had another case this morning. We had a final pretrial conference this morning.
Oh, okay. Nice to see you, Judge.
Same here.
I tried a case in front of you a couple of years ago with Wilson Copeland.
Oh, okay.
Yeah, nice to see you. Hi, Nathan.
Hi, Elizabeth. How are you?
I'm great. Glad to see everybody's well.
All right, I'm going to begin the recording so that I don't forget. Okay. Ms. Clifton.
This is case number 19003-409 N.O. Paula Weber versus Jonathan Munson.
Okay, Counsel.
Elizabeth Thompson appearing on behalf of the plaintiff.
Nathan Thomas, Your Honor, appearing on behalf of the defendant Munson.
Okay. Mr. Thomas, this is your client's motion, Mr. Munson's motion, so you may proceed.
Thank you, Your Honor. And I know that Your Honor has read the briefs and read the motions, and so I will in turn be brief. I just wanted to point out a couple of the more salient points, Judge. The first and foremost, Your Honor, is that the plaintiff in this case has presented no evidence whatsoever that Mr. Munson was negligent at all. There is no, first of all, as Your Honor was well aware, the prongs of negligence is a breach, a duty, a breach, damages, and then proximate cause. There's no evidence that Mr. Munson breached any duty to the plaintiff whatsoever. In fact, to the contrary, the only evidence that we do know is that there's no dispute that there was a fallen fence creating a tripping hazard. In fact, the plaintiff's own complaint suggests as much. And so if there's no breach by Mr. Munson, there is no proximate cause. If anything, the proximate cause lays with that fallen tripping hazard, that there is, again, no dispute that that fencing was fallen, creating a tripping hazard. We don't have any other evidence, Your Honor. We don't have blood alcohol evidence. We don't have anyone suggesting that Mr. Munson was running around or jumping around or doing anything other than what he testified he was doing. That's all we have, is that he was at an event that was crowded, walking around and tripped over this fallen fencing that was hazardly laying on the ground and unfortunately fell onto the plaintiff in this case. Nothing other than that, Your Honor, suggests that Mr. Munson was doing anything other than what said he was doing in his deposition. If anything, Mr. Munson himself may have had may have been able to sue the co-defendants in this case, but chose not to because he hurt his own leg when he fell over that fencing. That again was admittedly, by all parties, was laying on the ground in a crowd of people.
Ms. Thompson.
Yeah, thank you, Judge. First, Judge, this motion is just fraught with so many problems. First and foremost, the defendants have failed the requirements under the court rule just in terms of attaching anything to support their C10 portion of the motion. They have the burden of doing so, and they've completely failed to do that. Not only that, Judge, they have not cited one single court rule, case law, or bit of legal authority in support of any of their arguments other than in the standard of review section. So to that extent, much of what they're arguing, there's no legal support for any of that. They've also completely misstated the law with respect to the comparative negligence portion of the claim, which I can just touch on briefly later, but what they've indicated just quite simply isn't the law. Secondly, they have, or not secondly, but next, Judge, they have misstated so many facts. And not only does it create questions of fact, but they have simply misstated facts. One example is that Mr. Munson, they indicate in their brief that he had a half a beer. And I can cite multiple places in his deposition where he admits he was at the event, he was drinking before the event, holding a beer and drinking at the client, and was drinking after he fell on my client. And he admits in answers to interrogatories and in his deposition that he had up to 4 beers. Another woman who he was with was so intoxicated, the owner of the bar had to escort her out. And she was a police officer like the defendant, but she was so intoxicated, he had to escort her out because she was back behind the bar looking for her badge. So to that extent, again, the facts that they have provided to the court are not, they're not consistent with the evidence, Judge. Next, they are arguing, they're conflating this general negligence claim with what I surmise is the auto negligence law, Judge. They seem to suggest, they don't seem to suggest, they actually tell the court that my client needs to have some sort of threshold injury, which again, just isn't the law. They're suggesting that she should have some sort of serious impairment injury. And their argument that she didn't suffer an injury, again, we've provided to the court ample documentation from her treaters, but more importantly, they have an IME, their own defense expert examined my client. I've attached the report to my response for the court to see. And this report is very compelling at the time of, not only does he have an injury, but he finds that it was as a result of the incident. Are you there, Judge?
Yes, yes.
I'm sorry, things froze, so I'm sorry.
You're fine.
And he, not only did he find it caused by Mr. Munson in the incident, he recommended that she have further treatment. So to the extent that they claim she has no damages, that's just not, it's not even consistent with their own proofs. They also say they have my client, which again is entirely inappropriate, Judge, because they know that that's not my client. I advise them, it's my client's neighbor who was walking dogs. That is something I would completely disregard because they client the surveillance that they have. Just to touch on what brother counsel was.
You froze for a minute, so I didn't hear what you said about I think you were talking about a neighbor's dog.
Correct. They indicate in their brief, Judge, that they have surveillance of my client, which proves she has no injury. And they know, Judge, that the surveillance they have is not of my client. It's actually of my client's neighbor. So to that extent that they've represented that to the court, it's inappropriate. To touch on what brother counsel was referring to as far as a breach, they admit in their brief on page 7 that Mr. Munson owed my client a duty. Now we have sufficiently pled, this is a C8 and a C10 motion, breaches of that duty. I, in fact, asked Mr. Munson, don't you agree that you need to conduct yourself in a reasonable manner so as not to cause injury to others? And he conceded that point. Now, again, I refer back to the consumption of alcohol. Mr. Munson admitted that he had seen this fencing before the incident, admitted that it was bright orange, he described it as it being droopy and on the ground, and that he knew it was there before the fall occurred. And he's drinking. He turns to leave the area and falls. And he says he stumbled into my client. They seem to suggest that my client had some duty to herself, which is, with all due respect to brother counsel, ridiculous. That she had some duty to herself to avoid him. This is a very large man. My client's a very tiny woman. It was impossible for her to avoid him. The law is clear, Judge. And again, we have cited case law. They have not. I refer the court to the Heaton case, the Tucker case, and the Ghaffari case, that the defendant has a duty to refrain from taking actions that unreasonably place others in danger, which applies to every action a person takes. So there's no question when you're at an event like this and drinking alcohol and you're aware of a potential hazard, you need to exercise caution to not run into people. So I've alleged in the complaint all the breaches. I won't repeat them for the court, but I would refer to page 5 of the complaint, which is Exhibit 1. If the court would like me to review them, I certainly can do that. But again, Judge, there's clear negligence in this regard, and that the defendant did not conduct himself in a reasonable manner, and as a result, he caused these injuries. And just finally, Your Honor, again, this comparative negligence standard, the defendants have completely misstated the law. The law in Michigan is that it's a pure comparative negligence standard, and it's actually an affirmative defense. It's not a basis for summary disposition, and this question is a consideration for the jury. It's not for this court to decide for purposes of an MSD hearing. So to that extent, I would ask the court just to disregard that argument. And again, Judge, they don't have the law. The testimony is that the defendant himself provided is very persuasive, or at a minimum creates questions of fact. And I would just ask the court to deny the motion.
Anything in response, Mr. Thomas?
Yes, Your Honor, briefly, if I may. I don't need the comparative negligence argument. All I need is the standard of negligence, the elements, the prongs that haven't been met. There's a lot of talk about, oh, he was drinking alcohol. Again, Your Honor, the burden of proof was for the plaintiff to prove that my client was negligent or was somehow intoxicated. There are no blood alcohol screens. There is no evidence that he was intoxicated, other than she said, I had a few beers over the course of the night. That's not enough, Judge. On top of that.
But see, that's something for the trier of fact to make the determination whether or not that's enough. I don't see that I can do that as a matter of law, Mr. Thomas.
Understood. So, but Your Honor, also this talk that there was someone else that my client was there with that was intoxicated, that's completely irrelevant and inflammatory. There's nothing to do with my client whatsoever. And plaintiff attorney, their sister counsel talks about, actions, unreasonable actions. But which ones? There is nothing. There is no evidence that he did anything other than what he testified he was doing, which is walking around and tripping over a fence, which, by the way, Judge, you can't have it both ways. You can't say that I'm going to sue the property manager or the event coordinator over this fencing because it was a tripping hazard, and then say my client should have seen it. Well, if my client should have seen it, so it was open and obvious? Well, which is it? Is it a tripping hazard or is it not? So
I agree with you, Mr. Thomas, but then that's something that needs to be fleshed out by the trier of fact, not necessarily the court. There's a lot going on here, and as Ms. Thompson has indicated, we don't have any affidavits. It's all pure argument. We don't have affidavits. We don't have case law. It can be determined that there may have been a duty and a breach, but I don't think that's something that I can make as a matter of law, taking the evidence in the light most favorable to the non-moving party. We can go on and talk about the IME, which says that she has an injury and so forth and so on. And there's too much here for the court to make any other ruling other than that, taking the evidence in light most favorable to the non-moving party, that there isn't a sufficient basis for the court to grant a summary disposition. The plaintiff has been a case law in terms of exercising caution, but then again, I said that those are matters that need to be dealt with by the trier of fact, not decided as a matter of law. That being said, the court is going to deny the motion for summary disposition. So, and Ms. Thompson, you can present the court with an order by EFI just based upon what was placed on the record.
Okay, I will do that, Judge.
Okay, now we need to have a settlement conference, so I am going to excuse Ms. Cargill. Thank you very much, Ms. Cargill. Ms. Clifton will remove you from or you can just sign out, Ms. Cargill.
Yes, I can, and thank you for allowing me to sit with you today, Judge.
No problem. And I will stop the recording, and I will also end the YouTube live streaming. This concludes this hearing.